Donald Trump is so old, he is older than television. Donald Trump was born before television. But by the time he was 11 years old, through his teenage years, he got to watch Perry Mason from 1957 to 1966, starring Raymond Burr in American television's very first lawyer show. It was the big drama on TV in those days. Black and white, classic old TV. And one odd thing that it might take a while to notice when you watch reruns of old Perry Mason shows now, as I do, is that there is usually no jury in the courtroom. The writers justified that early in the series when they decided to stop using juries by having one of the lawyers involved refer to what was happening in court as a pre-trial hearing, or sometimes the judge would do that without ever specifying why all the witnesses were testifying at a pre-trial hearing that sure seemed like a trial. The reason there were no juries in Perry Mason's courtroom was to save money and time in shooting the show. And when you're shooting a TV series, saving time is money. The producers figured out quickly that if they didn't have to cast 12 people every week, 12 new people for a new jury, they could save that money and save time in the courtroom by setting up the cameras just on one side of the courtroom where the jury used to be and just shoot across the room. And in that one shot, they could easily capture prosecutor Hamilton Berger and the greatest defense lawyer in the world, Perry Mason. Just get it all in one shot, one cheap, quick shot. The no jury's decision must have saved them hours and hours a day in shooting time and saved them plenty of money that they could keep adding to Raymond Burr's well-deserved salary increases every year. Donald Trump, who grew up on Perry Mason, is now asking for one of those fake Perry Mason hearings in the Manhattan criminal case against him for making hush money payments to adult film star Stormy Daniels. The case is now in the discovery phase, with prosecutors having handed over all of their evidence to Donald Trump's criminal defense lawyers. The next significant proceeding in the case is the trial, currently scheduled for March 4th of 2024. But Donald Trump is asking for what his lawyers call an evidentiary hearing in the case to consider whether the case should be dismissed, which is District Attorney Alvin Bragg opposed in a motion filed today. The district attorney's filing says that Donald Trump seems to believe, quote, the ordinary rules for criminal law and procedure should be applied differently here. Courts have repeatedly rejected defendants' demands for special treatment and instead have adhered to the core principle that the rule of law applies equally to the powerful as to the powerless. This prosecution should proceed to trial. In his filing today, District Attorney Bragg described the case this way. Defendant Donald J. Trump is charged with 34 felony counts of falsifying business records in the first degree as part of an expansive and corrupt criminal scheme to conceal damaging information from the voting public in advance of the 2016 presidential election. And in Georgia today, as expected, Judge Scott McAfee issued a protective order controlling the handling of prosecution evidence given to defendants in the case of Georgia versus Donald Trump and multiple co-defendants, as was agreed to in an emergency hearing yesterday by prosecutors and most of the defense counsel. Prosecutors will label as sensitive material the evidence that should be subject to the protective order. The ruling comes after at least one defense lawyer in the case leaked video recordings of prosecution interviews with 4 of the co-defendants in the case who have pleaded guilty. One criminal defense lawyer, Jonathan Miller, representing co-defendant Misty Hampton, admitted in court yesterday that he leaked the video evidence to reporters. That does not mean that he was the only criminal defense lawyer who leaked that evidence. The lawyer said he leaked the video evidence because he thought some of it was helpful to his client. In Judge McAfee's order today, the judge described the possible effects of such leaks on potential jurors. Potential jurors should be limited from exposure to materials that may be deemed inadmissible at trial. One party may believe a piece of evidence should be considered by the public at large, while another finds it prejudicial and damaging to the jury pool. The court has an interest in ensuring that all parties retain their right to a fair trial before an unbiased jury, a process that could become unattainable should the public be allowed to vet every piece of unfiltered evidence months before trial.